When people think about reproductive rights, often the thing that they jump to is the right to terminate a pregnancy or the abortion right. But actually, reproductive rights is much broader than just the right to choose to terminate a pregnancy. It also includes things like the right to birth control, the right to be free from involuntary or coercive sterilisation, the right to reproductive health care, and the right to marry and found a family. So it is a lot broader than just the right to choose to terminate a pregnancy, even though that tends to be the most talked about reproductive right. The right to choose to terminate a pregnancy is not a standalone right as such within international human rights law. However, it has been conceptualised as falling within a number of established human rights norms. For example, the right to life, the right to health, the right to privacy or autonomy, the right to equality, also known as the right to be free from discrimination, and also the right to be free from torture and cruel, inhuman or degrading treatment depending on the circumstances. So depending on the specific factual scenario, the right to choose to terminate a pregnancy may fall within a number of those established human rights norms. Australia is a federal system, which means that laws, there are some laws which are formed under the Commonwealth's domain, and other laws fall within the domain of the individual states. Abortion is one of those issues that falls within the domain of individual states. So that means that the law relating to abortion is actually different depending on the state that you're in. If you're in Queensland, for example, then abortion is still a crime. And some of you may remember that in 2010, a young couple was actually prosecuted in Queensland under the abortion laws. In Victoria, in contrast, since 2008, abortion has been decriminalised. And so in Victoria, and most recently in Tasmania, and also in the ACT, abortion is no longer a crime. Where abortion has been decriminalised, doctors with a conscientious objection to abortion may still refrain from participating in the procedure. However, in both Victoria and Tasmania, the laws which decriminalised abortion also included a requirement for a doctor to, first of all, perform an abortion where necessary to save a woman's life or in an emergency situation, and also included a requirement that a doctor actually direct a woman where she can go to find out more about accessing abortion services, even if the doctor themselves has a conscientious objection to abortion. So there's no requirement that they participate in the procedure except in an emergency, but there is a requirement that they help to ensure continuity of healthcare, if you like. An access zone is also sometimes called a buffer zone or a bubble zone, basically because it essentially creates a bubble around an abortion clinic within which no protesting or harassment can take place. So the idea really is that women trying to enter the clinic to access the healthcare services in that clinic don't get harassed and put through unnecessary stress or distress when they're walking in to access those services. So in Tasmania, for example, is the first state in Australia to actually provide for access zones, and in Tasmania the access zone around an abortion clinic is 150 metres.